all the dignitaries on the dais and off the dais, I welcome you all on behalf of the Bar Council of India on this International Lawyers Conference. I request Mr. D.P. Dal to please kindly facilitate Justice J.K. Maheshwari. Now I request Shri Ajay Sharma, Chairman Bar Council of Himachal Pradesh, to kindly facilitate Justice Sanjay Karolche. Now I request Mr. I.N. Mehta, Member Bar Council of Himachal Pradesh, to kindly facilitate Justice Arpesh Kumar Singh. Now I request Mr. Rajiv Kumar Singh kindly felicitate Shri Radha Mukherjee. Now I request Mr. D.K. Sharma, Member Bar Council of India from Uttar Pradesh, to kindly do the honors to Shri Guru Krishna Kumar. Now I request to Justice J.K. Maheshwari to kindly start the session, please. Thank you. Thank you, Lordship.
Good evening to everyone present here. We know today's topic is justice delivery system, the impact of social media. Prior to starting to introduce the topic, I would like to show one slide. You see this slide first.
An event seen from one point of view gives one impression. Seen from another point of view, it gives quite a different impression. But it's only when you get the whole picture you can fully understand what's going on.
Now I will show with this slide how the impact of the social media is on the society and the system. So I will start again with this slide and explain. There are three perspectives in this slide. You see the first perspective of the slide is
an event Seen from one point of view gives one impression.
The first perspective is this man seen the police vehicle, started running away. So this is the first perspective. Meaning thereby, it's a negative perspective in the mind of a person. The second perspective.
Seen from another point of view, it gives quite a different impression.
Now you see this second perspective means this man is running and passes through, and then thereafter he snatches a bag. So it gives an impression this man is coming and going and want to snatch a bag of a man and pull. This is second. And the third.
But it's only when you get the whole picture you can fully understand what's going on.
So now this is the third perspective, meaning thereby a man who was running not for the purpose that he saw the police vehicle, not for the purpose that he want to pick up the vehicle, pick up the bag. He came with a perspective that he want to save a man from this fallen of the bricks and fallen of the stones. So these are three perspectives. If we see in a justice delivery system, how it impacts the social media. Now, so far as this impact to the social media is, as I explained, can be understood in three ways. One is positive, another is negative, and third is balanced perspective. All three you have seen. Now we'll give some examples of the positive impacts. If we go for the positive impacts, then it enables the advocates and judges to stay connected with the community. They serve and also have a better understanding of the social dynamics. One, acts as a powerful tool to spread legal awareness. Two, third, it provides a convenient and equitable access to information irrespective to the remoteness. And fourth, led to the introduction of the concept of e-hearing and live streaming. Now for these positive perspectives, I will put certain examples of the positive perspectives. Everybody knows about I will touch on a topic, otherwise my panelists will do. We know the positive aspect, how it has come by this social media. This is, we know the Nirbhaya's case. You know, one girl was raped in the vehicle at DTC. Then what happened? How the society reacted, how the social media reacted, and the consequence was a formation of the law. The another aspect is, if we see in the COVID-19 recently, because of the social media impact, so many people found that the hoardings and black marketers, they were doing? They were black marketing the oxygens, medicines, cognizance taken by the court, positive impact. Then thereafter, popularly known as Sushant Singh Rajput's case, guidelines have been issued by the Bombay High Court in the matter of the press reporting. And the fourth aspect which I will emphasize of this, during COVID-19, how the functioning of the court, because of need of our justice should not be denied to anyone, and the e-court functioning is in reality started by all the courts, that is Supreme Court, High Court, and all subordinate courts. So, and I can announce this, India is the country in the world who heard highest number of cases during COVID-19. So this is the positive aspect. Now I am coming to the negative impacts. What may be a negative impact of this social media trolling? This trolling comes. social media trials creating a prejudice narrative in society and the minds of the member of the bar and bench in respect of under trials. Excessive trolling and functionaries of the legal system by audience having lack of knowledge about facts, existing legislation, interpretation of law, and even they form their opinion. And third, defamation and invasion of the privacy of the stakeholders. It includes in the manner how the witnesses are going to be affected, how they be influenced. Number two, under trials, how both parties can be harassed, and unwarranted mailing and other things causes a coming to the reputation even to the victim. And third, how the advocates are being impacted on account of this social trolling. And the last is the judges. It may create a mind bias in the mind of a judge. It may create a verdict which may unnecessarily be invited from the mind of the general public, though it may be different on the perspective of a judge looking to the facts and the law as well as the interpretation of the law. So now these are the impacts. To put a recent example of the negative impact, we can take a very known judgment, known case of Gyan Bapi mosque case. This is there was a worshipper, Hindu worshipper, visited there. They said, I want to go and worship. Issue arises, suit was filed, matter brought. The other part of the impact is other community people also visited. Everything was beneath the land. They visited and they started showing the things in a different perspective. So this is the perspective. One, and created a communal problem. And finally, how the judge is being impacted. There was a threat. Judge retained. Finally, the Supreme Court intervened and the matter got transferred to the District Judge Banaras. So this is the impact, social media. You can know other cases also, narcotics case you know. Now, third is balanced impact. If we go for the balanced impact, by way of a live streaming, and it came to the knowledge, then it may result a quicker response and may give a positive impact. You can understand the Manipur violence in these days. It has come by through a social media. Number of the videos were shown, came, court come into the picture and started doing something, committee got appointed, and the action has been started. So these are three types of impact on the justice delivery system of this social media. Now today we have three panelists with me, along with Brother Justice Sanjay Karol, who will give the overview of the topic. We have first Mr. Rana Mukherjee, who will speak. He will start with an introduction, how this media to social media is converted. Then the second is Justice Apresh Kumar Singh, Judge, Chief Justice Tripura High Court. He will give the overall viewpoint, how the news impacts, social media impacts in functioning of the court and how it should be worked out. And third is we have Guru Krishna Kumar. He will give all overall impact over the advocates, Indian perspective, global perspective, and how it is to be faced with. So in that view, by this short introduction, I will invite Brother Justice Karol to give the overall viewpoint on the topic.
Good afternoon to all of you present here on the dais. My esteemed colleague, Honorable Justice Vishwe, Chief Justice Apesh, Mr. Rana, Mr. Guru Krishna Kumar, Honorable Civil Counsel from the Supreme Court. I can see in the audience dignitaries who have come from abroad, especially Peter Maynard, my colleagues in the different high courts, ladies and gentlemen. Take it. I'm so happy to be here. I feel that I am almost 20 years younger seeing the audience which is present here. Thank you, all of you, please. I'll just give a broad spectrum, an overview, as I have been asked by my esteemed colleague. Law is now of such a nature that it touches all aspects of life. Social media in the 21st century is acquiring a similar omnipresence. Before proceeding to the impact it has on judges and the judiciary as a whole, let us look at what arguably are the two sides of the same coin. Where on one hand, social media has contributed immensely to bringing real-time awareness to the processes of the courts, the judgments, the orders passed thereby, and even videos helping the layperson understand how the halls of justice function. My esteemed colleague mentioned about the video hearings during the time of COVID. Social media can be used for imparting valuable information such as holding of Lok Adalats, free legal aid camps, launch of different platforms, programs and schemes ensuring access to justice. To give an example of this online platforms have for the first time given a direct insight to huge number of law students, citizens alike, as to how the courts function and the deliberations that take place before arriving at the final conclusions. The lot of law interns here would know that actually how difficult the judge's task is. It is only after 5 o'clock that the preparation for the next day morning begins, and the law clerks along with the judges spend the night through preparing the briefs. They give live updates of not only the arguments placed by advocates, but also queries put forward by the bench. Live streaming of our constitution benches has given direct awareness to citizens about the deliberations in court in cases which concern issues or people around this nation as a whole. This purpose must be kept at the forefront while undertaking such reporting, particularly that sensitization of headline grabbing is not the intent. If this is taken to be their purpose, it shall only harm abound. Minute-to-minute reporting of utterances and observations is not appropriate considering the working circumstances. Here I must emphasize to my friends from the social media and from the electronic media that the judges are not celebrities, and neither are these online platforms paparazzi who would need to report all our movements. On the other hand, the availability of information at the snap of one's fingers, unchecked and unverified, leads to misinterpretation, and then on such unsound basis rests an opinion on the matter, leading to heated debates, which has often been termed as media trials. I need not give any illustrations, for my esteemed colleague has already done that. Snippets of oral observations or queries in court being made viral to seem like they are the final dictum that has fallen from the court, or that from live streams of the proceedings, certain clips, dehors of concepts are circulated widely. In such trials, the public, on the basis of half-baked information, more so for the reason that they are not aware of the niceties of the functioning of the courts, much prior to the courts having gone through the procedure to arrive at a verdict, pass judgments on the court of public opinion, giving way to great harm to the person subjected thereto. Now, this is starkly different from the era when I came into the profession, where we did not have an idea of what to expect when coming into court for the first time. Young friends, you're very, very fortunate that you have access to the courtrooms, which was not there when most of us on this side or on the front two rows came when we joined the profession. The question, in view of this omnipresence of social media and its demonstrable differences with the traditional older forms of media facing this panel, led by my esteemed colleague, Justice Maheshwari, is social media's impact on the judiciary. This, of course, comes with the given, that is, judges are not an exception to the reaches of social media. Most of those who are from the younger generation obviously would not agree. But let me tell you that there is a decision of the Honorable the Supreme Court in 1998, may not be contemporary or outdated in today's context, which reads, and I quote, "Judges have to live and behave like hermits who have no desire or aspiration, having shed it through penance." Now we, unquote. Now we must ask that in truth, shedding aside idealization, whether judges can indeed live like hermits who have no desire or aspiration. When the lifeline of the present day society in this form of media reforming from engagement reinforces the ivory tower syndrome, where it can be said that the judges are out of sync or out of tune with people. I may refer here to what Justice Kadzu had to observe in his book, The Nature of Judicial Process, and I quote, "I do not doubt the grandeur of the conception which lifts, that is the judges, into the realm of pure reason, above the beyond the sweep of perturbing and deflecting forces. Nonetheless, they do not stand aloof on these chill and distant heights, and we shall not help the cause of truth by acting and speaking as if they do. The great tides and current which engulf the rest of the men do not turn aside in their course and pass the judges by," unquote. The recent past of a court is replete with instances where utterances in court by the bench or the bar have created storms on social media, as also there are examples to show us the path how to respond. My esteemed colleague did mention that when more often than not the remarks made are decontextualized and misinterpreted, going so far as to morph into personal attacks and questioning the credibility of the judge and the lawyers. In my view, these are individualized viewpoints, possibly biased, which are diametrically opposite to constructive critique and would be expected of an informed populace. Friends, I may say this, that we as judges are open, always open, to correct ourselves. You have every right to express your viewpoint on the judgments which are delivered. But however, traveling beyond that is something which you need to contemplate. The actual need of the hour is to inform and educate the media on the restrictions on the freedom of speech. Every limb shall, to the extent permitted by the Constitution and other statutory restrictions, be free to function in its own sphere of influence without encroaching on the territory set aside for others' agencies. The commentary to the Bangalore Principles of Judicial Conduct was released in the year 2002. I shall not speak much on that because one of my co-panelists would do that. One cannot be removed from the way the world works. Thus, it is incumbent upon us to become experts, which of course is easier said than done in compartmentalization. As we are all too well aware, the legal profession demands of its people the ability to survive and thrive, but equally so it demands a great deal of self-discipline, restraint, and social media puts to test the latter too. Given that we are attending an international conference, it only fits us to draw wisdom from other jurisdictions. After all, social media and its interaction with the judiciary is a phenomena world over. The general message to be drawn from other jurisdictions across the world, I need not name the countries, is that the judges must abide by the core value of dignity, impartiality, independence in their views, consumption of social media, and in cases where they themselves do use such sites. Here I am not talking of the social responsibility of the social media, but how the judges should use the social media. They must abide by the code of conduct issued in that regard. A code of conduct may tell judges how to use social media, but it does not and cannot give us the answer on the influence of the social media. Contextually, illustratively, I'm reminded of a newly appointed sub-judge proudly posting his first pronounced judgment on a Facebook. And I need not say anything further. To address the issue of social media vis-a-vis the judges, a group of 25 judges from across countries together by the Global Judicial Integrity Network, a component of global program for the implementation of the Doha Declaration, recognize that social media presents both opportunities and challenges, a fact I have alluded to already and agreed that only adequate and personalized training could help judges navigate a new mediatic environment. I may emphasizingly say that I'm a votary of freedom of speech, and I believe it to be one of the most cherished values of our Constitution. I can see the former president of the coordination, chairman of the coordination committee of the Patna Bihar Association, and he knows that how open I was and in interacting with the bench in the bar, and I gave space, listened to everyone, views of everyone. And this, from my experience, I may say this, that it has helped me a long way. The chairman of the Bar Council of Patna is also here. Equally, I must acknowledge his presence. Not to say that the others are not known to me and I should not acknowledge their presence. But these are the people who have understood, whom I have understood, with whom I have worked and given them space, listened to them, and listened to the onslaught of the social media, yet survived, ensured that the institution functioned every single moment. However, such freedom, I'm adding, must, much like any other, is not unbridled and free of restrictions. Digital media has the freedom to gather and disseminate information to the public about the administration of justice so long as there are adequate checks and balances in the form of introspection, self-regulation, and restraint. I would not say that there should be a legislation for regulating the social media. It is not always wise to give answers to questions. I'm ending here now by saying that we are looking answers from those young people who are here to the issues which have been highlighted and which are going to be deliberated here during the course of today's deliberations. I sincerely hope that I've contributed in whatever measure and worth in today's deliberations. Thank you very much.
My Lord Justice J.K. Maheshwari, Lord Justice Karol, Justice Apesh Singh, Chief Justice Tripura High Court, my learned friend Guru Krishna Kumar. I have friends of the dais. Some of them I can see and recognize. Vikramjit Banerjee and Sai Krishna Kumar, Santanam, senior advocates of the dais and my friends and students particularly. So this is a very interesting topic in today's day and age. We are at an age where it is said that if you just flay your arms like this, you'll get some news somewhere. It is floating around fast and furious. People are always on the net. As of yesterday, India has recorded 757.47 million social media users. That shows a staggering figure, either of awareness or of interactive nature of our young generation. And I should not keep our generation out of it, because when we grew up, I grew up in a small mining town in Orissa, and the newspaper used to come a day late. And I remember reporting with regard to judicial decisions were far and few in between. Maybe a few landmark cases used to be reported, and the editor would put a note, and there would be letters to the editor the next day or the day after. So the impact of a judgment was lost in the print media. People never used to discuss too much, only people who are aware of the society at large then. Because, for example, let us take the Minimal Mills case or the Keshwanand Bharati case. To be very frank, even today, for me to decipher what Keshwanand Bharati did, it takes a toll on my health. It is one judgment where it is because of Supreme Court later on saying that this is what the judgment meant. You could understand that. Can you imagine a situation in today's day and age, if this judgment were to be pronounced today, the number of hits that would have made on the social media? I tell you, it's very interesting. A lawyer takes maybe a month to prepare a case. There are cases which can run into reams of pages. A judge then hears the matter and takes maybe 2 more months to deliver judgment. And the day the judgment is delivered, on that evening, social media platforms are tearing apart that judgment. One segment says this is a fantastic judgment. Even when we read that judgment after 5 months after arguing that case, we take time to understand as to why the judge held the way he or she has. But the social media takes 5 minutes. By the evening, we have legal experts on TV or whatever space, and they're tearing apart the judgment and the judges too. The lawyers are spared. Somehow the lawyers are spared. So we are in a slightly better position. Now, it's actually a very serious thing to note. I mean, where is the control? We can talk of Article 19, we can talk of Article 21 for people who are living through the social media, they're earning a living. But where is that line to be drawn? The line has to be a self-restraint, which the courts keep on saying. 19.1, 19.2, everything is there. But you should know your space, you should know your limits. If you do not know that, then you're transgressing into an area which is actually a very explosive area. You see, a judge can't defend him or herself. The judge does like Justice Maheshwari said, Justice Karol said, they do the best they can. And if a judge makes a mistake, maybe somebody will correct it one day. There's no harm in that. That's what the judicial process is all about. But why should we allow the social media to come about in such an aggressive manner and also influence the fate of a case. See, a Supreme Court judge or a High Court judge would have spent maybe 15, 20 years reaching where they have reached. They may not be impacted by all these comments which come fast and furious. But for a lower court judiciary, when someone, the first thing is, I do a lot of criminal cases for the prosecution also. After 20 years, a convict is acquitted. Now, for that moment, that evening when somebody is nabbed by the police, he or she is ripped apart on social media. The judge granting bail has to think 10 times because it seeps into his mind that should I grant bail? The world at large is watching me. What do we do? And a judge would normally succumb to that pressure. So best thing is don't grant bail, but let the higher courts do it. That's a very common phenomenon which is happening nowadays. And I don't blame the lower court judiciary. An impact of 757.47 million people on the net, out of which maybe 300 are trolling the judges, trolling the judgments. It makes a very sad reading of society at large. Now this, the young generation sitting at the back, you should utilize it for constructive purposes. Please take this seriously. Please do not use it for destructive. Do not get into any discussion. As a lawyer, we were told, do not unnecessarily discuss a matter in which you're not involved. How would you know what the facts of the case is? How would you know what the lawyer has argued? Mr. Kumbhakarni is here. He knows how difficult it is in Maharashtra to really argue a case without being trolled. So, I mean, we are living in a very, very complex society, complex world, and in which how much can the judges do? Can they keep on issuing contempt notice? No, they can't. Earlier, the first reported case of contempt was on EMS Namboodiripad, if you have heard of his name. He was the Chief Minister of Kerala. He had come out very strongly against the Kerala High Court judgment, and there, the 2:1, the Kerala High Court held him guilty of contempt, imposed a fine of 1 year, 1,000 and 1 year. The matter came to Supreme Court. The Supreme Court then, in its own wisdom, deciphered as to why he should not have said what he said, and imposed a fine of 50 rupees only. But that went a long way into saying that there was a Privy Council case also of 1944, which is the first reported case, of how journalists should behave and how journalists should report. Assuming Namboodiripad had said something, the journalist could have twisted that into his own words and presented a very gory picture of what the Chief Minister had wanted to say. But nevertheless, the Supreme Court imposed a fine of 50 rupees and said that he is guilty of contempt. Then there were other cases leading to Arundhati Rai, where she criticized the judgment and she was sentenced to 1 day imprisonment. Now, can the judges on social media, which has such a wide platform, keep on issuing contempt notices? They can't. So recently, a Supreme Court judge said, we have a thick skin, we can absorb a lot. These criticisms don't hurt us. And that's a very telling statement. Like Justice Maheshwari also said, that a judge has to be alive to the situation. You know, be have an armor on your head. Let things pass by. Social media will exist. Nobody can deny the right. Social media responsible users will exist. Irresponsible users will also exist. The numbers may be more on the other side. It's for us to take and sieve out the best from the worst. Now, as far as the young generation is concerned, Justice Karol also said we had no access to judicial decisions earlier. Now you have n number of platforms. Please utilize your time reading judgments. Try and understand, because your job is to become a lawyer. I understand most of them are law students. And not be on social media criticizing people and entering into dialogues where you should not enter. Now, having said that, I must also bring to the notice of this panel a recent judgment of the Delhi High Court. And a single judge of the High Court has now called upon the government to frame guidelines and rules for the social media. Justice Swarnalata Sharma, I think, she's also said that the impact of blocking children below 18 has to be looked into seriously by the government. And this is a very telling statement. We have had Supreme Court judges remarking in matters, though it is not in writing, of matters where social media seem to influence the outcome of a case. For example, I can take the name of the Arnab Goswami case. And before I end and hand over to the other panelists, I must tell you there was a legal journal, which is Bar and Bench, and had taken strong exception to it. A now retired Chief Justice had gone in his private time to his hometown He was apparently seen on a mobike, looking at some costly mobike. And that went viral. We had lawyers commenting on that platform. When I told Bar and Bench, you should not have a comment section. That is his private time. Look at what it could have impacted that Honorable Chief Justice. He would have done it in all innocence. Doesn't he have a right to lead a life? He can go and look at a mobike, he can look at a Ferrari, he can look at a Lamborghini. Whether he buys or not is something else. But the way the trolling happened, and I had to write to Bar and Bench to say, please stop it, don't have a comment section. You're a responsible legal magazine. So it is a two-way street. You have to hold on to your responsibilities. You have to give space to the judges to do their work, and please help them in deciding cases the way they should. And with this, I end, because now we'll have Justice Apres Singh talk on the social media impact on judges, and an interesting oversight of the social media impact on lawyers will be spoken of by Mr. Guru Krishna Kumar. Thank you so very much.
A very good afternoon to all. Honorable Justice J.K. Maheshwari, Judge Supreme Court of India. Honorable Justice Sanjay Karol, Judge Supreme Court of India. Senior Advocate Sri Rana Mukherjee, Sri Guru Krishna Kumar on the dais, eminent senior lawyers of the dais, distinguished lawyers from abroad and from our own country, dear students. I was reminded of this adage when I was invited to speak in this job with yesterday's methods and be in business tomorrow. I was just imagining when learned speakers were speaking before me, and I was reminded of my own father, now about 85, 86 years old. And I see him on the phone and WhatsApp, and he was born sometime in 1938, when the telephones were not there, the air conditioners were not there, the rail lines were also not there, and how a different challenge was there at that point of time. The challenge of food crisis, the challenge of an independent, a colonial India seeking independence, and every generation has to face challenges. Likewise, though we have progressed on many fronts, but today we have a different kind of a challenge. Our minds are so reactive that whatever is being told, we respond. Instead of responding to that, we are reacting to that. And media earlier, print media, electronic media, now it is the social media. A sense of spirituality is to be looked into in every personality, which I'll come on later in my address. But as a judge, I would address this topic from the perspective of how to approach this impact from the judge's point of view. For the judicial system, social media was something alien. When the COVID-19 pandemic struck, there was uncertainty all around, be it on the extent or seriousness of the pandemic or of the consequences of the pandemic. It would be safe to say that the COVID-19 pandemic changed our world forever, and that change was quite remarkable when it comes to the judicial system. Our Constitution ordains the judiciary to dispense justice, to ensure that justice is accessible by one and all. With the onset of COVID-19 pandemic, the very concept of access to justice was subjected to an unprecedented challenge, never faced before. As already spoken before me, the judicial system commendably rose up to the challenge and responded remarkably to the situation by befriending technology without any hesitation to ensure that access to courts is not impeded. Social media is a term of diverse connotation, which includes not only the technical advancements of video conferencing and live streaming, but also encompasses the widely used social networking, communication, video content platforms like Facebook, Instagram, YouTube, etc. It is in this diverse station of social media we must understand and address the topic of this seminar. More so, because various aspects of social media have got divergent impact on the judicial system. Video conferencing technology ensured that the access to justice remained unimpeded and the disruption of judicial proceedings at the pandemic times was redressed by this aspect of social media. Another aspect being live streaming ensured that the judicial proceeding reached the masses in real time. However, with technological advancements also come the drawbacks, and it is only the balancing act of the advantages with the drawbacks/disadvantages that the system keeps progressing. Renowned jurist Benjamin Cardozo in his book, The Growth of Law, has beautifully remarked, quote, "Existing rules and principles can give us our present location, our bearings, our latitude and longitude. The inn that shelters for the night is not the journey's end. The law, like the traveler, must be ready for the morrow. It must have a principle of growth," unquote. Both the positive and the negative impacts of social media have been touched upon by Honorable Justice Maheshwari, Chairperson, and Honorable Justice Karol, Co-Chair. I would also like to highlight some of the positive impacts of social media. First of it could be to ensure access to justice by making justice remotely accessible and mobile. Today we can expect and do witness a lawyer sitting in his chambers in a remote part of the country with internet connectivity addressing arguments before Honorable Supreme Court in Delhi. The other day on Thursday, while I was sitting in a division bench in Tripura High Court, a learned counsel was addressing us from Chennai through virtual meeting. And the case was decided. We heard him patiently and delivered the judgment. Second, ensuring transparency in judicial proceedings. What happens in court stays in court was a thing of the past. With courts adopting to live streaming, litigants or the whole public at large can access, witness court proceedings with the click of a button. Third, ensuring continuity in dispensation of justice. With advent of virtual court proceedings, there are far less disruptions in the judicial proceedings. Even if a judge is out of the station, he can still hold court virtually. And similarly, a lawyer, if not physically present, can address the court virtually from a different part of the country. Fourth, wide information with technical advancements. The legal resources have become far more accessible, and it has made the work of legal research simpler. Fifth, better preparation. In my experience, I have witnessed lawyers to be better prepared in virtual proceedings, to be more concise, and they address the issues in a more articulative manner. They have picked up the practice of preparing short notes of arguments in most of the virtual proceedings, making things faster and easier for both the bar and the bench. And this request has been well received by them. Economic advantages. There are varied schools of thought so far as economic benefits of technological advancement is concerned, but in all its practicality, it has resulted in some positive economic impact for the entire judicial system. Less printing, less commuting, cost benefits for litigants by saving of travel costs, etc. At this juncture, I must clarify a widespread misnomer that it is not the judicial system that was reluctant to adopting itself to technology. It is also required to be mentioned that the Supreme Court mobile application has eased access to case information, all of which demonstrate that technology was seeping into the judicial system. The negative impact of social media. With every progress, there are concomitant drawbacks, the degree of which is varied. With social media and legal acumen to actually understand the proceedings of a court of law, how a matter proceeds, what does the remark of judges mean, the usual courtroom banters, admonishment by the bench, outburst of the bar, etc. The courts have their modes and methods of functioning, and none other than the bar can decipher it. What all is said and done in courts are not at times what it seems and looks, and it is only the trained legal minds who understand the purport of the court proceedings. Court proceedings turning into soaps of entertainment. Virulent and personal attacks on the judges. These are the negative impacts. Over scrutiny in name of transparency. We have witnessed trends of each and every remark made by a judge being subjected to trolls and scrutiny by non-experts. Transparency never encompasses non-experts adjudging the capability of the judicial system. Privacy issues, which has already been touched upon. One other negative impact of social media, which I thought of touching upon, is on the investigating agency as well. They are all stakeholders in justice delivery system. The widespread social media comments also affect not only the accused but the victims, the witnesses, and also not to leave behind the lawyers. They influence the judges also. I do not wish to venture into, however, in my practical experience, trained judicial minds are immune to such frailties. But at the same time, any personal attacks on the judges on social media is distressing for the judges. I am reminded of the words of jurist Benjamin Cardozo, which has been quoted by Honorable Justice Carroll earlier, that the great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges by. Social mediaification is reality not only of the judicial system but of every dimension of life. Be it praises or criticism, the same are transmitted with lightning speed. In the internet age, any small comment or a small happening has got a propensity to become trending or viral to such an extent that the same catches our attention and propels us to give a reaction. We all have started reacting instead of responding. All said and done, the social mediaification has put our patience and perseverance to testing times. This has resulted in a heavy burden on the systemic structure of our country, of which the judicial system is also a part. The religion of the judicial proceedings is to dispense justice without any bias and with fairness. Judges have to deal with all misinformation, misconceptions, uncharitable remarks, and still the magnanimity of the judicial institution demands that the judges remain unaffected, their adjudication remains pure. This calls for a deeper spiritual introspection by all of us. We can take a clue from our ancient scriptures. I would like to conclude by quoting two verses from the Bhagavad Gita. Yatha dipo nivatstato nenagate sopama smrita yogino yata chistasya yunjato yoga matamana. It means, like a lamp does not flicker in a spot where there is no wind, similarly the concentration of a controlled mind is unwavering. Yato yato nischarati manas chanchalam asthiram tatasto nitya metyada atmaneva vasham nayet. Whatever causes the restlessness, unsteady mind to wander away, he must restrain it and bring it back in control from within. From the judge's point of view, I would like to again re-emphasize that we are not supposed to be fallible to such frailties. We need to immune ourselves from the influence of social media in a negative manner and try to do justice in an impartial and a fair way, which I believe the Indian judicial system is up to the task. I thank the organizers, BCI, for conceiving and organizing such a wonderful conference on such a variety of topics which affects the legal fraternity and the judicial system. And I thank them for giving me an opportunity to speak before this august audience. Thank you. Jai Hind.
My humble greetings to this distinguished gathering, comprising of Justice Maheshwari, Justice Sanjay Karol, Justice Aparesh Kumar Singh, my good friend Mr. Rana, and all the dignitaries of the dais. Coming in as the last speaker in a seminar of this nature, and in the late afternoon immediately after lunch, which is typically a siesta time, and that too when the distinguished panel has virtually exhausted all the nuances which one could think of on the subject, I really find myself in a very unenviable position. Just the other day, I was one of the last to go in a long drawn-out constitution bench case. The court said, yes, you wanted to make some submissions, please start. I was forced to refer to the apocryphal son-in-law in Hindu law, which is attributed to Sir Alladi. There is supposed to have been a Hindu law case under uncodified Hindu law, which was being heard by an English judge way back in the early 20s. The judge was made to go through all these complicated questions of Mitakshara law, Dayabaga law, and all the other nuances attached to that. It was such a long-winded hearing, the judge was getting exasperated. Tongue-in-cheek, he asked Sir Alladi, who was present there, yes, Mr. Alladi, please tell us, they are saying this is what the daughter will get, this is what the son will get, this they say is a co-parcenary, whereas that is a self-acquired property. Please tell us what the son-in-law would get. Pat came the reply from Sir Alladi. He said, whatever he is able to lay his hands on. I am precisely in that position. Mr. Rana very charitably said about lawyers and all the other things Mr. Guru Krishna Kumar will cover. But it has been such a comprehensive consideration. Let me see whatever I'm able to lay my hands on the subject. Now, I think 55 years back, I'm reminded of what Alvin Toffler said, that futurist said, and I think they are very pregnant words. The illiterate of the future are not those who can't write and speak, but are those who cannot learn, unlearn, and relearn. Talking of social media today, I decided what I learnt about media, what I learnt about reporting, what I learnt about basic human interaction communication, I need to unlearn. And I thought I should relearn. So I called one of my junior colleagues in the chamber and asked him, can you please tell me something about social media? And what are the words and what are the frequently used expressions in social media? First reaction was, he said, please go onto the net, you will be able to find out. I said, please be a little more helpful. Please tell me something, because that's what we are used to. And when I talk about this generation and our generation, I feel very, very odd, because it is as though we are an old generation. No, it's not. Anyway, he said, sir, do you have a social media page? I said, what is that? I don't have. He said, sir, then you have not even gotten into nursery. Then he asked me, what is your social media engagement? I said, what is that engagement? I remember only an engagement when I got into the institution of marriage. He said, sir, no. Social media engagement is the amount of following that you have on social media. So I am not a spiritual guru, though my name is that. So I don't have any followers. So he said, sir, test number 2, you failed. Then he went on to say, sir, if you want to see something worthwhile on the net, you go onto the YouTube, look at it for some time, you switch off and go back again. That YouTube connection the second time will automatically give you all those topics and all related videos of the topic that you've just surfed the previous time. I asked him how. He said, there is something called social media algorithm. Likewise, he went on. Then he asked me one more question. Sir, are you on WhatsApp? I said, yes, I'm on WhatsApp. I insist that whoever takes me in a group they take my permission and thereafter put me in the group. So he asked, so you're not an admin in any WhatsApp group? I said, no. He said, sir, then you're not even in the first year of undergraduation in WhatsApp University. Ladies and gentlemen, all that was in the light vein. To contextualize the topic, today, the effect of social media is so uncompromising and so significant and so rapid and massive, one starts wondering if somebody can have an existence which is not part of social media. Now, obviously, social media is therefore having its effect on the justice delivery system as well. Talking of the impact of social media, I'm immediately reminded of that interesting case in the US just a few years back. The Supreme Court of Florida was tasked with looking at the question as to whether a judge who has one of the lawyers appearing for one of the parties as a Facebook friend, is he disqualified from hearing the case? The matter torturously, it was actually, if I remember right, at the instance of a law firm against its client for breach of contract. And the client as the defendant had engaged an attorney who was previously once a judge. And that gentleman as a judge, he knew the presiding officer, the judge who was hearing this case. And they were Facebook friends. So an objection was taken saying that they are friends, therefore the judge should not hear the case. The matter traveled right through and went to the Supreme Court of Florida, and the court said the mere fact that they are Facebook friends would not be a disqualification. Now, this is just one aspect of the problem that we are talking about. Now, this has churned up, this kind of approaches, this kind of a dispute, this kind of controversy has churned out tremendous debate in Western jurisdictions. In fact, Florida has come up with guidelines on what kind of behavior, social media behavior, should be followed by judges and presiding officers. I came across a non-binding guidelines by under the aegis of the UN, by the UN Office on Drugs and Offenses. There are non-binding guidelines for judges. Justice Karol spoke about the Bangalore Declaration. Now, Bangalore Declaration, according to me, is very interesting. It sets out the 6 core values. I'm not going to detain more time of this audience on what those 6 values are, but one of them is important. While talking of propriety as a value, the Bangalore Declaration says any judge who has interaction with members of the legal profession must function in such a manner that it does not give rise to any reasonable doubt of impartiality or bias. Now, this Bangalore Declaration, please recall, was made as far back as in 2001, when social media explosion was not as massive as what it is today. But the enduring value of something like that continues to be relevant even today. What's important is, I spoke about that case in the US, about a Facebook friendship, whether it disqualifies a judge from hearing a case. A very interesting article on that subject, on that decision, spoke as to how this judgment would be some kind of a guideline for judges and lawyers as to how they should function in social media. It says, yes, judges and lawyers being part of social media is definitely having a green light, but then it's a light of caution. It's a green with an amber. And what is important is, that article went on to say, and I found that to be very interesting, it said, any approach to social media participation of judges and lawyers should be looked at not from the point of view of any ethical standards as we look at it today, but on traditional considerations of what is right and wrong, and well understood, well established principles of what is right and wrong, which is where I thought Bangalore Declaration, talking of propriety, is something which is extremely relevant. Now, this is so far as judges are concerned. The other side of all this is the role of lawyers and what kind of social media impact is there on lawyers. Mr. Rana, in the course of his submission in the passing, said, the subject of troll are only judges. I dare say it is not so. Now he is clarifying, being a good senior counsel, he is clarifying now, saying it's mostly judges. I must say, please speak to lawyers who appear in politically sensitive cases. Please interact with lawyers who appear in otherwise socially relevant or debated cases. The kind of social media attention and the kind of social media trolling that they go through is something which has to be seen to be believed. Ladies and gentlemen, we are during times when momentary celebrity status is what is unfortunately being pursued by people. Social media, which is supposed to be such a fantastic medium for interaction of people instantaneously and on such a massive scale, is suffering, in my respectful thought, misuse. This is where the problem arises. Justice Maheshwari spoke about Nirbhaya's case. I remember one of the then sitting judges of the Supreme Court, because I didn't want to mention the name specifically, way back in a seminar in 2015, called upon, in a public seminar, called upon people to be careful in their usage of social media, not to troll or not to discuss cases without any sense of responsibility. Justice Maheshwari, as I said, spoke about Nirbhaya's case. He spoke about that Sushant Singh Rajput's case. These are all some examples. I'm reminded of that Arushi Talwar's case. All of them are cases where the social media was the judge, jury, and prosecutor together, all rolled into one. One other very interesting case, again going back to the international perspective. All of us heard about this defamation proceedings initiated by this famous actor Johnny Depp. Now, Johnny Depp sued his spouse for defamation because she wrote an editorial for the Washington Post saying that she was a victim of domestic abuse. Now, the interesting part about that case is, long before he succeeded, the social media had punished his wife. Now, this problem is something, therefore, which is live, current. It is something which is creating a pressure on justice delivery. It is creating a pressure on all the stakeholders. Justice Apresh Singh rightly spoke about the subconscious effect media campaigns have, where there is a media trial by which there is conviction and damning even before the matter has gone through with all its plenitude, with all its factors, with all its angles in the court of law where it should. This is where the problem arises. This lady, the wife of Johnny Depp, had been damned by the media long before the decision was taken by the jury and the judges. And one significant aspect, and I think one redeeming feature in India is, we at least today don't have the jury system. The problem with the jury system is that this kind of social media presence makes a very big difference. The judges are trained to think dispassionately, not to be carried away. But then, with all that, I cannot but be referring to what Justice Frankfurter said back in 1946. Talking of contempt law, Justice Frankfurter said, if only judges were angels and journalists were not people who are trying to interfere or comment on pending matters, where we had angelic judges and angelic lawyers and journalists, there would be no problem. But at the end of the day, all are human beings, subject to frailties, and therefore said the need for law of contempt. In fact, Mr. Mukherjee referred in the passing to the contempt law. Contempt law, many of you will be aware, contains provisions for criminal contempt where there is any writing, publication, or conduct which interferes or even tends to interfere with the course of justice in a pending case. But the question is, for something as massive something as widespread and something as significantly impacting and so fast in its operation as social media, can contempt law work? In fact, there is a very interesting discussion way back, I think in 2004 or 5, in the 200th Law Commission's report on the effect of media. That was a time when we still looked at media and not social media. There, the Law Commission recommended that this distinction between judges and juries, and that judges are beyond any kind of pressure at the mental level, is something which should be observed. And it recommended further additions to the contempt law even then, but they have not been really made part of the statute book. The reason why I'm highlighting all this is this. All this shows that the impact of social media on justice delivery is something which is very, very significant, and unfortunately for the most part, is something which is capable of distorting results. That's very important. In fact, the kind of discussion and virulent, if I may say so, spreading of information and character assassination taking place, it is so bad. We have cases today before the Delhi High Court, I think at least 2 cases are there, where petitioners whose cases have been concluded have moved the court for asking for deletion of their references on the internet, saying they have a right to be forgotten. Today, this is the level to which we are moving. And talking of this kind of an influence, constitutionally speaking, we are looking at 2 competing interests. Article 19, right of freedom of speech and expression. Everybody has that right, subject to reasonable restrictions. We are looking at the overarching public interest of the right of the public to know. And this has to be balanced with the right to a fair trial, particularly in criminal cases, going back to Article 21. And here, the role of lawyers, again, is something which is very, very important. I, speaking for myself, personally speaking, do believe that there needs to be in place some kind of regulations for this. Lawyers, as I said in the beginning, who appear in such sensitive cases, the kind of intense scrutiny that they are put through is to be seen to be believed. We have overnight jurists springing up saying that this point ought to have been taken. That issue has not been argued properly. The judge asked X question, but the lawyer unfortunately did not answer properly. And those who are writing of that, I dare say, have no experience in appearing before a court of law, leave alone going and standing in front of 20 people. Therefore, these are factors which are very, very important. These are factors which are very germane when we are looking at social media impact on justice delivery. Having said that, one cannot be oblivious to the pluses of social media. The transparency, the reach. At the end of the day, sunlight is the best disinfectant, no doubt about it. But too much of sunlight can burn, can cause a scar. I am afraid we are hovering very dangerously towards something like that. And again, speaking one more angle about lawyers, I again personally believe some regulations must come into place. We have the Bar Council of India rules on conduct of lawyers. There must be some serious look on participation of lawyers, either in social media or in electronic media, especially in cases in which they are appearing or have appeared. I, for one, with a traditional approach, do believe that perhaps it is not appropriate for a lawyer who has appeared in a case or who is appearing in a case to go on media or on social media and talk about the merits or demerits. Even otherwise, when a lawyer is called upon to a debate or a discussion, I would think that it is with a great sense of responsibility and proportion that any views must be expressed. Because a lawyer who is supposed to be trained in the law, any views that he gives is capable of influencing public opinion. And that can generate so much more of opinions and views. Ladies and gentlemen, therefore, these, I think, are some of the immediate concerns and issues which I wanted to flag. And I hope that this will generate some kind of further debate and maybe bring about some sense of proportion in the usage of social media by people. Having said all this, I must confess, it is with a sense of trepidation that I'm saying this. There was this apocryphal supersonic jet which was being flown where there were some 150 passengers. At one stage, the captain from the cockpit declared very triumphantly, dear passengers, I'm happy to tell you that the technology improvement is such that today your flight is at a speed where we are approaching the speed of sound. There was instant rejoicing in the cabin because we have reached so much of technological heights that we are approaching the speed of sound. But immediately, within the next second, there was a pall of gloom. Why? Because the captain said, but unfortunately, I do not know what is the direction in which this flight is going. Today, that is the predicament we have. Social media, as a tool, has tremendous potential, both positively and negatively. I leave it to the present-day generation to think about it, reflect on it, and come up with solutions. Thank you very much.
You can understand when Guru Krishna Kumar was speaking, as usual when he argues the case, I have heard him, so I can say he is very much impressive during argument. But today I can say his argument is appealing and to be applauded. So, concluding remark of this session, prior to going, we have heard, as usual, Rana Mukherjee, Abresh, Brother Karol and Guru Krishnamurti. Everything here in India, when it closes, then it goes to the cricket. And we see cricket match, and I will put an example of one positive aspect of this by way of similar example with the children and having a meeting with the Virat Kohli. You have a video and you will find out and what is the impact of it.
आज से 10-20 साल पहले किसने सोचा था कि इंडियन टीम में एक दिन खेलेंगे MS धोनी, विराट कोहली और हार्दिक पांड्या, सहवाग, सचिन और गांगुली बनके। ये देखो, एक बच्चे का मुझे DM आया, हाय विराट सर, मैं और मेरे फ्रेंड्स रोज क्रिकेट खेलने की कोशिश करते हैं, कोशिश, पर कॉलोनी के अंकल आंटी हमें खेलने ही नहीं देते। अब एक सीनियर क्रिकेटर होके हेल्प करना तो बनता है ना। हाय, अरे यहाँ कोई करण सेठी को जानता है?
सपने बड़े।
हाय
विराट,
क्या हुआ, आपने मुझे DM किया था?
अरे वो अंकल आंटी है ना, गुस्सा करते, बॉल भी वापस नहीं देते।
अच्छा,
हाँ।
चलो कोई नहीं, आज हम खेलते हैं। मैं बैटिंग करूँ क्या?
सर अगर आप बैटिंग करोगे तो हमारी बैटिंग कैसे आएगी?
अच्छा ठीक है, मैं बॉलिंग करता हूँ। आ जाओ फील्डर्स।
सपने बड़े, इनको लेके देखो ये चल पड़े। इन्हें रोको ना, इन्हें रोको ना, ये उड़ने को चले, उड़ने चले।
अब आंटी नहीं देने वाली बॉल।
मैं ट्राई करूँ क्या?
करिए।
आ जाओ।
इस बार बॉल नहीं मिलने वाली।
मैम बॉल दे दो प्लीज। देखो अगर मैंने शॉट मारा होता तो आप बॉल दे देते ना। जब मैं बच्चा था, अगर मुझे किसी ने रोक दिया होता तो शायद आज मैं टीम में नहीं होता। बच्चों को मत रोको प्लीज।
नहीं मिली।
बॉल मैं लाया हूं, अब मैं बैटिंग करूंगा। चलो थैंक यू। नहीं, शुरुआत यहीं से होती है। अरे यार फिर से तुम लोग मुझे मरवाओगे आज।
On this video, the impact was recently Uttarakhand High Court taken a cognizance that the playgrounds which are available, the children having their personal liberty to have play and go on the field. So that is the positive impact. What I want to convey you now, I have to emphasize Guru Krishnamurti's issues. It is very nice. One poet said, Abdullah Alim, he said, जो दिल को खबर है कहीं मिलती खबर नहीं, जो दिल को खबर है कहीं मिलती खबर नहीं, हर सुबह एक अजाब है अखबार देखना. अजाब means distress. I am coming. हर सुबह एक अजाब है अखबार देखना, distress. Again the question arises, how this issue of the social media and its impact on the judicial system, how it should be maintained, how it should be regulated. I think there should be a regulation on social media to the degree that it negatively affects to the public good. Social media in changing the way we communicate and the way we are perceived, both positively and negatively. Even time you post a photo or update your status, you are contributing to your own digital footprint and personal brand. New age's social media requires new age's solution. We cannot solve our problem with the same thinking we used when we created them. Albert Einstein said, this may be used in the context that modern problems like influence of social media requires modern solutions, and we possibly cannot deal with them if we go old ways. New laws, guidelines for new problems relating to social media. So now the regulation so required. I will go for a perspective. We can see for this regulation. I will put in another example. You would have heard the name of one Indian movie, Kabir Singh. The impact was one girl and boys fall in love, heart is break, some altercations took place, and the boys started eating. Social media start trolling here. What trolling is? Can a boy who's having some affection can do this? The other aspect is when they are friends, they can do it, but we are not supposed to do everything. And we have to think positive. And I put in last words some questions on you to think how the social media impact. I put certain questions on you, think, go and answer to yourself. Can we regulate perspectives? If we can, will it always be in favor of public good? How can we balance and regulate public good and freedom enshrined under Article 19 of the Constitution? There are some pertinent questions which I want to leave you with to ponder upon. Please think, use social media, how and how far it is required and how much it is to be used. Thank you very much to everyone. We can, if time permits, we can ask 2-3 questions. If people can ask, we can think of 2 or 3 questions. Thank you. Yes, please.
A very good afternoon to all the dignitaries. Sir, as we have discussed that social media impacts negatively to the psyche of the public at large as well as the judges. And it is obvious that if the judges are influenced by that, it may have a negative impact towards their justice delivery as well while they are making the judgments. And sir, as Justice Maheshwari, you just said that modern problems require modern solutions. So sir, what is your take on the fact that artificial intelligence or AI should be integrated in the Indian legal system so that the justice delivery is not only unbiased but also reluctant free on delivering the judgment?
Yes. Artificial intelligence.
I think the red one is the red is what is it? The red one.
Yes, artificial intelligence has been introduced and it is a part of the judicial system. So far as now it's used to that extent to check the trolls and otherwise that cannot be regulated by the artificial intelligence, and its regulation can only be possible. And this question you can see that recently Justice Chandrachud in the judgment had issued the direction to the central government to go out with some regulation or some SOP, and that should be placed before us. So artificial intelligence alone cannot check it. At present, we can say to that extent.
Yes, sir. Thank you, sir.
Yes, please.
Good afternoon, dignitaries. My name is Aishwarya Ambar and I'm from Christ deemed to be University. So my question is, in the era of social media being high on people and they're taking over people's opinion and everything, sir, there is still an unregulated domain, that is the dark web. So as we legal professionals, what are the ethical and legal implications we should follow for the same? As we legal professionals on dark web?
You please.
It's only a coincidence that Justice Maheshwari said regarding dark web you speak. It's not that I'm experienced. Both the honorable judges very promptly dispatched me to the sites and said, no, come on, you have to answer this.
That was more out of ignorance.
No. See, dark web, according to me, is one of the negative fallouts of internet. Every technological innovation and advancement has its own advantages. But I dare say that some of this is disruptive, and the dark web is reflective of that. And to an extent, it reflects the baseness of the human mind also. That's where there is misuse of technology. That's how I would put it.
Answer is perspective.
Absolutely.
I started to this, today's topic is perspective. So please, perspective must be,
Yes.
you can see balancing. And finally, it must be a balancing perspective.
Indeed, sir. Thank you for your valuable response, sir. Thank you.
One last question at the end.
Good evening, sir. So thank you for addressing the conference on social media's impact. But what do we talk about? How do we talk about the impact of the media, the channels, the news channels on justice delivery system when they are constantly putting the case on media trials? We formally know of the Sushant Singh Rajput case or any of the cases where the anchors are giving out their own judgments and influencing the media, because I think that is that media holds the biggest impact on the society. So what is the role of the courts in regulating what TV channels are reporting and how the journalists are reporting the cases of the court cases?
No, you're right. The electronic media has its own role to play in this also. That cannot be disputed. It so happens that today social media is so very prevalent and so very extensive in its reach, and instantaneously at that. and advice that the topic of discussion is social media. This does not take away from the fact that electronic media has its own problems, apart from its pluses. I remember one Chief Justice of India once mentioning how the print media, to a certain extent, is responsible because it has regulations. The electronic media comes second in line in terms of regulation because most of it is self-regulated. So they also equally have a responsibility, and the impact they have by way of conducting media trial is something which cannot be denied. I remember in those days before social media became very prevalent and active, for example, there is rain in Bombay. You have channels who have taken a shot of water leaking from a particular pipeline and repeating it over and over again as though the entire city is flooded. No, these are all some of the problems we have had. So therefore, your point is well taken, that electronic media has its own issues with regard to media trial, which needs to be regulated. And the third in that order is social media. Thank you.
I can tell you in this way, lastly, whenever there is a case or trial is pending, whenever the people doesn't know, the media doesn't know what is in the charge sheet, they doesn't know who are the witnesses. Even sometime we found that the witnesses have been brought to the social media or electronic platform and certain questions are being asked. So it is distress to the social media. And in such a cases, our wholehearted request is we should not indulge in all this.
Thank you, Lord Chair. Now I will request my colleague, Prashant Singh ji, to give a vote of thanks.
I'd like to thank Chairman of the session, Honorable Mr. Justice J.K. Maheshwari, sir, Judge Supreme Court of India, Co-Chairman of session, Honorable Mr. Justice Sanjay Karol, sir, Judge Supreme Court of India, Honorable Mr. Justice Aparesh Kumar Singh, Chief Justice Tripura High Court, Mr. Rana Mukherjee, Senior Advocate, Mr. Guru Krishna Kumar, Senior Advocate, Supreme Court. All honorable member of State Bar Council present over here, eminent lawyer, professional, student, giving their precious time and gracing this occasion. Thank you so much for this session. Thank you so much.
Hello. Hello. Hello.
Thank you. Hope everything is fine.